Okay, Assalamualaikum warahmatullahi wabarakatuh. My name is Iqwami Kamaruddin. Okay, today I will present about contract law. What is contract law? Contract law is a set of rules governing the relationship, content, and validity of an agreement between two or more persons regarding the sale of goods, provisions of service, or exchange of interest or ownership. Okay, for the others is the type of contracts. There are lots of type of contracts, which the first one is bilateral contracts. The second one is unilateral contracts, express vs implied contracts, formal vs informal, executive versus executory contracts, valid contracts, voidable contracts, and void contracts. After that, I will talk about element of contract. There are 8 elements of contract, which is the first one is offer and acceptance, agreement, consideration, intention, consent, capacity, legality of form, and legality of purpose. Okay, for the next slide is I will talk about breach of contract. A breach of contract is a violation of any of the agreed upon terms and conditions of a binding contract. Happen when one party breaks the terms of an agreement between two or more parties. Is the contract valid? The simplest way to prove that a contract exists is to have a written document that is signed by both parties. Okay, for the case that I will present is the case of Adams v. Linsell on 1818. For the key fact of the case, the court that they'll do the case is King Bench. For the full case name, Adams v. Linsell, decide for 5 June 1818. The judge sitting is Law J. The case opinion is Law J2. Okay, this is the chronology or the key facts of the case. Adams wrote to Linsell offering to sell him 800 totes of wool. Adams asked for a response within 2 weeks. A few days later, Linsell wrote back agreeing to the orders. However, the letter was misdirected. As the result, it arrived 2 days after the deadline. In the meantime, Adams had already sold the wool to a third party. Linsell sued Adams for a breach of contract. Okay, for the next slide is I will talk about the holding of the case. The Court of King Bench upheld the rule of the trial court that when forming contract by marriage, acceptance is valid from the time of mailing a letter containing language of same. Because defendants, in their offer, notified the plaintiff of their terms that they would waive acceptance in the course of post. They were bound by the terms of their offer until it was accepted or until the terms of the offer has expired. Plaintiff accept within the course of post by mailing same and therefore manifest a valid asset. The rationale of the holding. A valid contract was formed, offer was accepted when the letters were posted, not when it reached Mr. Adam. It is important to remember that the Melbourne rule is a default rule, meaning that parties to a contract can opt out of using this rule by the terms of their agreement. When offers are made via mail, acceptance is complete upon mailing. However, be careful to note what the terms of the offer are. For a conclusion, for the case of Adams v. Linsell, therefore has 3 consequences in English law. Firstly, a post-acceptance prevails over a previously post-withdrawal of the offer which had not yet reached the offeree when the acceptance was posted. Secondly, acceptance takes effect on posting even where it never reached the offerer or only does so after delay. Finally, the contract is taken to have been made at the time of posting so as to take priority over another contract made after the original acceptance was posted. Okay, I think that's all for me. Thank you for listening to my presentation. I hope you enjoy it.